Rights Court. My name is Igama. I am a former participant of the SABWiL the SABWiL Human Rights Court. So, the ninth annual SABWiL Human Rights Court is a gathering that not only celebrates the spirit of South Africa's constitution, but also reflects the enduring legacy of Nelson Mandela's vision for justice, equality, and freedom. As we mark this occasion, we are reminded of the historic moment in 1996 when South Africa's constitution was signed into law, a document hailed worldwide as one of the most progressive and transformative. It is a living testament to our collective commitment to uphold the values of dignity, equality, and freedom. But this commitment is only as strong as those entrusted to interpret, defend, and apply this constitution. The lawyers, advocates, and judges of tomorrow. Today, we are here not just to deliberate on constitutional principles, but to nurture the very talent that will safeguard these principles for generations to come. Competitions like this are more than academic exercises. They are the crucibles in which skilled, empathetic, and courageous lawyers are forged. This Mooncourt program offers a unique opportunity to tackle real-world challenges such as today's focus on whether minimum sentencing provisions violate Section 12 of the Constitution. These are not merely hypothetical debates. They are the questions that shape lives, define freedoms, and ensure justice for all. Through the rigorous preparation, critical thinking, and persuasive advocacy demanded by this program, participants gain not only technical legal skills, but also the moral clarity to wield the law as an instrument for positive change. These are precisely the qualities we need in our judiciary and legal fraternity as we navigate the complexities of a rapidly changing world. The development of skilled lawyers capable of applying constitutional principles to better our nation is not an abstract goal, it is a necessity. Every court ruling, every legal argument, and every judgment has the potential to affect countless lives. It is the lawyer's responsibility to ensure that these impacts are just, equitable, and reflective of the constitutional values we hold dear. By participating in this program, each of you is taking a step towards fulfilling this responsibility. You are learning not only to argue the law, but to embody its spirit, an essential quality for anyone who seeks to advance human rights, challenge injustice, and create a fairer society. To the organizers of this prestigious event, thank you for creating this platform that empowers young legal minds to think boldly and critically. To the participants, I commend you for stepping into this arena, knowing that it demands your very best. You are not just competing for recognition today, you are laying the foundation for your future role as custodians of justice. Remember, the law is not static. It evolves through the courage and creativity of those who practice it. Let today be a reminder of the profound impact you have as legal professionals and agents of change in society. As we proceed with today's program, let us keep in mind that this is more than a competition. It is a celebration of the power of law to transform lives and a reaffirmation of our collective dedication to may today's discussions inspire all of us to continue striving for a South Africa that truly reflects the vision of its founding charter. With that having been said, I will now call upon the 6th SABWiL President, Ms. Ayanda Ndlovu, for her presidential address. Thank you.
Joyous morning, ladies and gentlemen, esteemed justices, honorable counsel, and distinguished guests. My name is Ayanda Ndlovu, and I warmly welcome you all to the 9th Annual SABWiL Human Rights Court as the 6th President of South African Black Women in Law. Today we gather to commemorate the signing of our Constitution, a milestone that marked the beginning of our journey towards a democratic society. I would like to extend my heartfelt gratitude to SABWiL's National Executive Committee and the founder of SABWiL, Advocate Aisha, for their tireless efforts and dedication to our organization. Your hard work has been instrumental in making this event a success. Today, we are going to discuss Section 12 of our Constitution, the right to safety and security of a person. We are reminded that the importance of upholding human dignity and promoting a culture of respect for human rights. To our justices, counsels, participants, I thank you for your dedication to upholding human rights and promoting justice. Your contributions to this noble cause are invaluable, and we are grateful for your presence here today. As we celebrate our Constitution and the values of South African Black women in law, let us reaffirm our commitment to creating a society that is just, equitable, and free. Let us continue to work together to promote human rights, to uphold the rule of law, and to build a brighter future for all South Africans. Thank you. I am now going to read the case scenario of Section 12. The Polokwane High Court declares the minimum sentences provisions prescribed in the Criminal Law Amendment Act number 105 of 1997. Section 51, in breach of Section 12 of the Constitution of South Africa, considering the constitutional values which include Ubuntu. This court is now asked to confirm the declaration of invalidity in terms of Section 172, subsection 2 of the Constitution of South Africa, Act 108 of 1996. The first applicant is a national association, founded by a daughter of a live prisoner and duly constituted, that represents the interests of custodial prisoners and their families. Lifers Matters works towards conditions for those sentenced to imprisonment in South Africa and fights against dehumanization of convicted persons, with a strong focus on restorative justice and Ubuntu. Life imprisonment and mandatory imprisonment sentences lead to overcrowding and inhumane conditions, impacting hygiene and parole possibilities without any positive impact on the crime levels it contains. Life Matters adopts the notion that we can only have a South Africa free of crime if evil is met with good, if hatred is neutralized through acts of love, Ubuntu. Retribution that is at its heart exclusively punitive simply adds to the cycle of the crime, leading to endless violence. Of note, even Elon Musk, in an interview with podcaster Lex Friedman, streaming on YouTube, similarly advocated conspicuous acts of kindness in response to questions about the Gaza war and the solution or the lack. The second applicant is Tatari Bosha, a plumber convicted of murder and sentenced by the court to imprisonment. The respondents are the state prosecuting authority and the Minister of Law and Detention. The state prosecuting authority and the minister oppose to the confirmation of the declaration of the Polokwane High Court that the mandatory minimum sentencing provisions offend the Constitution. It stands by the precedent established by the Constitutional Court in the cases of Dolo, Zuguda, and Masini as definitive, initiating a dismissal. Victim Alliance joins the proceedings as a friend of the court. advancing the rights of victims and law-abiding citizens who wish to live in a crime-free South Africa, where those who offend the laws and harm its citizens are punished severely. The harshest punishment secures the rule of law and deters self-harm. Part of their ideology is the return of the death penalty. Restorative justice and Ubuntu are not acceptable prescripts to survivors of heinous crimes who affiliate with Victims Alliance. Offenders must pay for the harshest penalty upon conviction to ensure perpetrators are deterred from criminal activities and to foster the rule of law, lest renegade victims are moved to take the law into their own blinded by anger. That is all. Thank you.
Consideration. That is the role counsel plays in such proceedings. Before we start posing questions to the judges, it becomes necessary for us to know who will be posing those questions. So, at this point, what I will be doing, I will ask Ms. Malibongwe to essentially come and introduce the bright sparks that are before us today. I will ask her to essentially introduce counsel for the applicant, for the respondent, counsel for amicus, so that we all know who is who and who is doing what. Ms. Malibongwe.
Representing the applicant, we have Nino Broda, who's the SC. Yes, Nino, very good. With Nino, we've got Shrutia Siva Kuma, pardon me if I said the name, I tried as much as I can. Shrutia Siva Kuma. That's Shrutia, who's the junior counsel. And representing the respondent, we have Anele, who will be the senior counsel. With Anele, we have Nathan Maratike, who will be the junior counsel. And lastly, we've got the amicus curiae, who will be represented by Lesego Sihona as the SC, and Fana Bayola as the junior counsel. Right, thank you very much, ladies and gentlemen.
Case number 712 of 2024 in the matter between Life as Matter, Isibo Shwadafa versus State Prosecuting Authority and Minister of Law and Detention and Victim Alliances. With Justices Tyree, Adam, Naidu, Jara, China presiding, court is now in session.
Good morning, my justices. My name is Nina Roda, and I'm the senior counsel for applicants. I'll be taking 8 minutes of the court's time, and my co-counsel, Shrutia Sivakumar, who will take 7 minutes of the court's time. We'll be reserving 5 minutes for rebuttal. I'll be making 3 submissions, and my co-counsel will be making the rest of the submissions. My submission will be around the doctrine of stare decisis, or rather the precedent, the unjustifiable limitation of Section 12, and also the irrationality of mandatory minimum sentencing. May it please the court, may I go to my first submission, please?
Thank you, Ms. Roda. Thank you, Ms. Roda. You may proceed.
Thank you. My justices, applicants submit that stare decisis does not extinguish this application. It is not contested that the Constitutional Court's previous decisions are binding on any other courts. However, our applicant would like to draw this court's attention to the following: that the ratio decidendi of a court in a previous matter is dependent on the material facts of a case. So, in other words, if material facts of the case do not resemble the current matter, we cannot argue that the previous decisions, such decisions are binding to the current matter. In other words, the case can have different matters, but the courts can only decide one or two issues that the applicants are raising. However, some issues are left out for the new decision. For example, the S versus Dodo 2001 case focused on the constitutionality of Section 51, subsection 1 of minimum mandatory sentencing. Very similar to the current matter, we are also challenging Section 51, subsection 1 of the Criminal Law Amendment Act. However, the difference is this, that Section 51 of the Criminal Law Amendment Act in S versus Dodo was challenged through the lens of an accused right to fair trial. That's your Section 35 of the Constitution, as opposed to the current matter, which is Section 12 of the Constitution. Particularly freedom not to be punished in a person not to be punished in an inhumane, cruel, and degrading manner. Another difference between the current matter and S versus Dodo is that S versus Dodo was mainly focused on the imprisonment itself, but the current matter is focused on the consequences of imprisonment. Particularly, the current matter raises the question, in what conditions do prisoners are forced to serve their life sentences in? In what conditions are prisoners have to serve their life sentences in? We also believe that the political context of S versus Dodo is very drastically different from the current matter. We had death penalty abolished in 1995. We had the Criminal Law Amendment Act introduced in 1998, and we had this case decided, S versus Dodo case decided in 2001. So, removing the death penalty on one side and declaring Section 51 minimum mandatory sentencing unconstitutional would have resulted in a crisis where the public would have felt hopeless and would have lost their confidence in criminal justice. However, today, in 2024, we have a situation where we are faced with overcrowding and what the overcrowding does to the prisons. Therefore, we submit that it is not constitutional, or rather rational, to hold the previous decisions of S versus Dodo to Cuda and the Masakili case binding on the current matter, because as they argue, the current matter raises different types of issues. As it pleases the court, this concludes my first submission. May I move to my second submission, please?
Okay, Ms. Roderick, please proceed.
Okay, thank you. Our second submission is that the Section 12 is unjustifiably limited. Section 12 of the Constitution is unjustifiably limited by mandatory minimum sentencing. According to the Judicial Inspectorate for Correctional Services quarterly report, 1st January to 31st March 2024, the 3-month period, reveals that at least 37 deaths of inmates were a result of respiratory complications, including TB. According to the same report, some inmates were forced to sleep on the floor as due to the lack of mattresses. Furthermore, hygiene conditions and available healthcare services were found to be inadequate in prisons. According to the World Health Organization, creating an unhealthy environment for prisoners creates creates rather health complications, including but not limited to cancer and any other diseases. As applicants, my justices, applicants submit that mandatory sentencing directly impacts or rather creates overcrowding. How does mandatory sentencing create overcrowding is that it increases prison population and also it increases the duration, how long can prisoners stay in the prison. For example, if prisoners, according to mandatory minimum sentences laws, person can go on parole only after 25 years or after they serve 4/5 of their sentencing. Or if their sentencing is 25 years, 4/5 of their sentencing will be they have to serve 20 years before they can be considered for parole. If it's a 10-year sentence, they have to be 8 years in the prison before they go on to parole. So this creates a situation where you have people longer in prisons and creates overcrowding. Overcrowding creates health issues as reported to the reports I mentioned. Now, mandatory sentencing impacts Section 12 right of prisoners not to be punished in inhumane, cruel, and degrading manner, and not to be arbitrarily deprived from their freedom. That now we have to test Section 12 and Section 36 of the Limitation Clause, my justices. Section 26 of the Constitution requires that the nature and extent of the limitation of the right must be proportional and related to the purpose for which the limitation is imposed. In this instance, the extent of the limitation of prisons in Section 12 right is that jeopardizes their mental and physical health. So, the extent of limitation, how far the law, Section 51 limits the Section 12 right is far-reaching. It's not only puts the prisoners into a prison situation, but it forces them to be in that overcrowded situation. It enables them to get sick in the prisons and to the health to be jeopardized. For example, in our client's case, he has to spend 18 hours with 18 hours out of 24 hours in the prison with his 90 inmates. So a total of 20 inmates, where the capacity for the cell is 10 people. So we submit. Okay. It looks like my time is up, my justices. Can I quickly wrap up? Please do so. Okay, thank you. So the extent of limitation is quite far-reaching, and the purpose of the minimum sentencing does not serve its purpose. In fact, we know that the crime is going up. This said, limitation is not justified in Section 36 of the Constitution. Thank you so much.
Are there questions from any of the justices?
Counsel? You can just let me know whenever.
You mentioned the consequences of imprisonment and the consequences, the conditions of imprisonment. Does the conditions of imprisonment are the conditions of imprisonment dealt with by the minimum sentences legislation?
Conditions of... May you repeat your question, please?
Dealt with the consequences of imprisonment and the conditions of imprisonment. Does the minimum sentences legislation, which is before us today, impact on the conditions of imprisonment?
Thank you, Justice. We applicants submit that it does impact on the conditions of imprisonment. The Section 51 of the mandatory minimum sentencing does impact on the conditions of imprisonment. By the fact that the prisons are overcrowding and it contains double as much people as it's supposed to be. It creates unbearable situation where prisoners' health is compromised. In one room, there are 20 people instead of 10 people. That creates mental and physical issues. For example, we have some figures that shows that there has been homicide cases, there has been a suicide, and mainly, and mostly, the figures reflect that has been an assault from prisoner to prisoner, from officials of prisons to the prisoners.
Okay. But is that not, as you referred to in your heads of argument, applicable to the Correctional Services Act and not Act 105 of 1997?
We argue that it has indirect effect on prisoners, the conditions in the prison. So Section 51, subsection 1 has creates indirectly overcrowding, if I'm making sense.
Thank you.
Ms. Roder, is there anyone else you want to? Yes. Justice Igama.
Good morning, Mr. You have argued that the Dodo case is distinguishable from your case. Now, my understanding of the Dodo case, and when it came to the High Court, and in particular with reference to Section 51(3)(a, the Act specifically shows that a court may impose a lesser sentence if the court is satisfied that there are substantial and compelling circumstances. Now, with regards to the aspect of overcrowding, and your issue being that mandatory sentencing causes overcrowding, in a situation where the court does find that there are substantial and compelling circumstances, therefore this person, instead of being sentenced hypothetically to 15 years, will now be sentenced to 3 years, does that still not contribute to mandatory, does that not still contribute to overcrowding? How is your case going to elevate the representation? How do you propose that if we move from 15 years in a particular case to 3 years, how's the overcrowding resolved? Because that person will still end up in the courts, in the jail system.
Thank you, Justices. If we reduce the staying period in prisons, what happens is that we're looking at rather coming up with different solutions as opposed to the mandatory minimum sentencing, other alternatives that can help to not just serve the justice and proportionality of sentencing, but also to reduce indirectly the overcrowding in prisons. My co-counsel actually deals with the matter of alternatives, but we see and believe in alternatives, and we saw already that the minimum sentencing doesn't have effect of deterring crime. It rather puts people in one room in a prison situation, and not only not only help to deter crime, but also affects prisoners' right to health and right to not to be punished in humane, degrading way.
Thank you, Ms. Roder. This is the aspect I'd like you to assist me with. The mandatory minimum sentencing legislation implies that it should be executed in a humane manner. So if it's mandatory minimum sentencing, the Department of Correctional Services should ensure that the prisons are not overcrowded, that one prisoner is incapacitated in a way that exudes dignity. So is it really the administration and the execution that is the problem, or is it the legislation? Before you answer that, I will share with you that my perusal of the Judicial Inspectorate, the report for correctional services, the JICS report, speaks to overcrowding not only because of the minimum sentencing. It speaks to it and indicates that prisons are overcrowded because we have human beings incapacitated because they cannot pay for bail of 1,000 rand. So it's an economic reason. Had they had 1,000 rand, they would have been able to pay for bail and they would not be part of the in the prisons. There's another reason that prisons are overcrowded, and that is that we have a lot of non-South Africans, persons that are not South African that need to be deported and that are in our prisons. So that's reason number 3 for overcrowding. In terms of the JICS report, another reason for overcrowding is that we have awaiting trial prisoners. Prisoners are waiting trial for at least 2 years. So there's not only one factor that your submissions for your client is about minimum sentencing. There are 3 others in addition to that. So what do we make of that? Because that's the Judicial Inspectorate report that is current, the annual.
My Justices, can you repeat your question, please?
Yes. So, the prisons are not overcrowded simply because of, we accept they're overcrowded, but it's not only because of minimum sentencing prisoners that are serving sentences in terms of the minimum prescribed legislation. It's overcrowded for other reasons. So why is it not then an administrative problem that the prisons are not big enough? They haven't been budgeted sufficiently for all the prisoners. It's more an implementation and how the legislation is implemented and executed, as opposed to a challenge to the legislation itself. So what I'm saying is, I will need to be persuaded that the legislation can be challenged, because from what I see in the JICS report, it's how the legislation is actually being implemented. Had we had a budget, or had the budget been expended to ensure that there are more prisons, bigger prisons, more food, more rooms, to house all these prisoners, then there wouldn't be this problem. So, is this not a question where you need to direct your attack towards the Department of Correctional Services as opposed to an aspect of legislation? So that's the one question. But where I possibly may be persuaded is of the increase of crime. So then is it fit for purpose if crime is increasing? Because there's two angles to your submission. So the one angle, I think I've demonstrated to you why I'm not persuaded on the aspect of overcrowding, because that is more implementation and administration and execution, as opposed to the actual legislation. But I may be persuaded on whether the legislation is a deterrent and fit for purpose in terms of the crime increasing. So if crime is increasing, and the whole point of the legislation is to be a deterrent, then is it rational is the public power exercised in a way that it is rational? So I would like your assistance now that you see the problems that I have. What do I make of it?
Thank you, Justice. So I get you what you're saying. I hear you that the state, or rather the executive, plays a role in institutes to have to provide for more prisons, for more facilities for prisoners. The fact is, it hasn't happened so far, and the executive hasn't really done much about it. But what we submit is that the Section 51, the mandatory sentencing, creates overcrowding directly, which then affects the prisoners itself.
Why are you attacking something that's the problem indirectly? If the manager, if whoever is managing the issue is not doing their job, why attack the actual task or the mandate? Why are you not directing your attack to the correctional services? Why the democratic will of the people to have that legislation? Why is that being challenged? And why are you not directing to who is implementing that? Or let me ask you this in a simple way. Can it be cured if can all these overcrowding issues be adequately cured if the Department of Correctional Services employs more funding or does whatever it needs to do to address these concerns?
Yes, it can. It can cure the problem. To provide more facilities means that you have more beds, less people in one cell. But we're challenging the legislature.
If the problem can be solved from the department's perspective, then clearly the issue isn't with the legislation, because the legislation, it should be construed that it's aligned with the Constitution and that it will be implemented in a way that protects the dignity of individuals. So we cannot bypass that. And then the second point, so I'm not with you on that. The point that I may be with you on, and I thank you for your concession, because it means that we can adequately address the real issue, which is the increase in crime. So is it fit for purpose, and what do we make of that?
Is the legislation fit for its purpose? Is that your question, Justice?
Taking into account I'm saying I am supportive of that solution, that if crime is increasing, then certainly we have a problem on whether there's a rational basis for the deterrence.
Yes, the crime is increasing. And the deterrence itself. So the legislation itself, I think, focuses on the deterrence only, and shies away from other alternatives, such as the rehabilitation or restorative justice, which is part of the rule of law. So we cannot rely on certainty, predictability, and those principles of rule of law only. We see the solution also in proportionality of sentencing, and also the restorative justice, which is aligned to Ubuntu. So we believe that deterrence itself does not or has not solved the current problem of overcrowding, and also the crime itself in our society. So there are other alternatives that perhaps we should look into.
Thank you, Ms. Roger. We look forward to hearing the submissions on this. Thank you very much. Ms. Sivakuma, you may proceed.
Justices of this Honorable Court, my name is Shruti Sivakuma, and I will deal with the issues of mandatory minimum sentencing, frustrating the purpose of the Correctional Services Act, as well as the issue of a just and equitable alternative to mandatory minimum sentencing. Thereafter, I will address the issue of costs and close with applicant's praise. I'm beginning with the objectives of the Correctional Services Act. The Act aims to foster a society whose members all contribute towards its well-being. This is evidenced by the reference to social responsibility in sections 2, 36, and 37 of the Act. It is further confirmed by the case of Wallace, which where the Constitutional Court reiterated the importance of rehabilitation of prisoners and stated that the objective of the criminal justice system and the Act is one of restorative justice. As the Correctional Services Act makes reference to international law in its preamble, it is useful to turn to Article 10.3 of the International Covenant on Civil and Political Rights, which states that social reintegration should be the primary focus of prison management. All of this evidence supports the idea that sentencing and imprisonment, and by extension the Correctional Services Act, is aimed at making offenders better individuals who begin to contribute positively to society. Mandatory minimum sentencing results in prisoners being imprisoned in environments which are physically and mentally harmful, while crime remains unsolved. An individual cannot be rehabilitated if they are not afforded adequate access to the resources to do so. Mandatory sentencing does not only result in stagnation of development, but indeed makes it more probable that offenders remain criminally inclined as they are not rehabilitated. This court, in the case of Wallace, emphasized the importance of creating a robust criminal justice system which does not incarcerate individuals indefinitely based on an inflexible set of rules, which is often the result of mandatory minimum sentencing. The constitutional right to dignity, which is further enshrined in Section 37 of the Act and in Rule 1 of the Nelson Mandela Rules, is significantly implicated. It is commonplace that being relegated to overcrowded prisons with complicated parole systems and insufficient resources results in an undignified livelihood. The concept of Ubuntu is ignored by minimum sentencing as there is no consideration for the inherent dignity and intrinsic value that humans possess. Minimum sentencing being the standard from which the judiciary can only deviate in exceptional and compelling circumstances results in prisoners being forgotten by society and forced to live out their days in a degrading and undignified manner. By forcing new and old offenders to accept inadequate health care, overcrowded accommodation, and insufficient mental enrichment, mandatory minimum sentencing renders the Correctional Services Act and the Constitution itself mere written documents with no practical implications. The applicants thus submit that mandatory minimum sentencing frustrates the purpose of the Correctional Services Act and the objectives of Ubuntu and restorative justice. If the court has no questions for me at this time, I would like to turn next to just and equitable alternatives to mandatory minimum sentencing.
Ms. Sivakuma, I would propose that you complete all your submissions and then we enter question time, if that will work. So continue and then thereafter we'll engage.
That is useful. Thank you, Justice. As noted in the case, I turn now to the just and equitable alternatives to mandatory minimum sentencing. As noted in the case of Williams, administrative justice requires that a procedure is both administratively feasible and in line with human rights considerations.
serve as a worthy deterrent, even if, and perhaps only if, it is a second resort. It is not contested that imprisonment offers victims of crime a particular peace of mind that alternatives may not provide. The case of Carmichael illustrates the risk of re-traumatizing victims as well as endangering society at large if offenders are not securely incarcerated. However, mandatory minimum sentencing has proven to be an unsuitable remedy for peace of mind and public protection, as seen by the rising crime statistics that have not reduced in the time during which mandatory minimum sentencing has been effective. Effective use of alternative resources will thus serve both public and fundamental rights of prisoners. A flexible following of the Tokyo rules, which emphasize adequate training of law enforcement officials, will result in the success of alternative measures. It is submitted that a sentencing commission be formed in order to not overburden the courts, and that victim impact statements, as well as statements from involved law enforcement officials, be taken or revisited when making a decision on how the sentence must be carried out. It is further submitted that the sentencing commission must review prisoners who have previously been incarcerated and sentenced, as the lack of retroactivity will result in unfair pressures and will not remedy the current state of overcrowding in prisons. This principle of retroactivity is supported by precedent, where prisoners on death row had their sentences revised at the abolishment of the death penalty. I will now turn to the issue of cost and praise. The applicants request that the violation principle be applied to this matter, as it is in the public interest to have this constitutional case be heard. This case deals with not only the Section 12 rights of prisoners, but the Section 12 right to be free from all forms of violence of the public itself. Mandatory minimum sentencing has proven to be an unworthy deterrent of crime, and thus its implementation implicates not only prisoners, but the public at large. The applicants further pray that this court confirms the constitutional invalidity of Section 51 of the Criminal Law Amendment Act, confirms the sentencing order made by the Qualifying High Court with respect to titillating bourgeois, and further awards any alternative relief as it sees fit. If it pleases the court, our submission is thus concluded, and the bench is free to make questions.
Parties out there that do commit crimes. Having that background in mind, what are your solutions on the section that allows the court to depart from that consistent background when there are substantially compelling circumstances?
If I understand your question correctly, you're asking whether departing from a consistent background is feasible or not.
What I'm asking is that in the background that we have a minimum sentence because of the consistency requirement on one hand. However, in this particular circumstance, we see that might not be feasible because there might be substantial and compelling circumstances. So why would the court then confirm, this court confirm that section is unconstitutional when there is a way out for the accused because of the requirement, the substantial and compelling circumstances? The section is not inflexible. There is a discretion. That is the question. Why should we declare the entire thing unconstitutional when it does have a way out? There's a back door.
Thank you for your question, Justice. We submit that there's a fundamental flaw in Section 51 itself, and by requiring that the courts repeatedly implement the proportionality test developed in the case of Case v. Malgus, we're wasting judicial resources and requiring a continuous departure from the legislation, which in any case renders the legislation useless.
Can you just elaborate on that wasting of judicial resources?
So, if the purpose of mandatory minimum sentencing is consistency, it is clear that requiring this type of compelling circumstances means that counsel must always create arguments that prove the compelling circumstances. So it is no longer just a base argument, but there is an argument above and beyond the baseline arguments to prove that there are compelling circumstances, which lengthens the trial process, further contributing to people awaiting trial in prisons. And in any case, if the mandatory sentencing is not followed, we have come to the same conclusion and we've come to the same result that we would have had if the legislation did not exist in the first place. Have I answered your question?
Yes, you have. However, what I want to ask then is, so are you then implying that each case should not be considered on its own facts and counsel should not spend time arguing the facts of that particular case?
We do submit that each case must be argued on its own basis, but we're saying that mandatory minimum sentencing makes it difficult as counsel must argue, particularly pandering to the proportionality test, as opposed to just arguing their case on a piecemeal basis.
So arguing the matter on its own particular facts, is that not still required in every matter?
That is required, but we submit that mandatory sentencing frustrates that, as it requires not only arguing each matter on its own basis, but it requires that a proportionality test to be undertaken in order to determine the appropriate sentence.
Thank you.
Just another.
Counsel, will you concede that the minimum sentences legislation is directed at very serious crimes?
Yes.
Now, the state has an obligation to deal with these serious crimes in light of the Constitution and enact legislation to deal with the problem. Do you agree with that?
Yes.
So my question to you is, with regard to the seriousness of the crimes provided for in Act 105 of 1997, how would you say that addressing these serious crimes, the nature of these crimes, which is not only murder like in the case before us today, it deals with robbery with aggravating circumstances, it deals with serial rapes, it deals with multiple murders. These are real serious issues and very, very with criminals who were hardened and have serious intent. How does the minimum sentences legislation frustrate dealing with these criminals? It's not your ordinary criminal, it's a serious, so deal with the seriousness.
Thank you for your question, Justice. It's submitted that mandatory sentencing does not serve any purpose in terms of deterring those serious crimes, as seen by 20% of the population being scared to walk around during daytime and over 60% still being unsafe to walk around during nighttime. Crime, even the most serious of crimes, have only steadily increased, with over 50,000 rapes being reported yearly. So we submit that mandatory sentencing by itself does not serve the purpose of deterring the most serious of crimes.
Counsel, but you also say that the minimum sentencing provisions solely contribute to the increase in crime.
No, Justice, we submit that it's not serving its purpose. So we submit that there is a coalition of forces that results in an increase in
sentences, the minimum sentences, are not contributing to the deterrence of crime.
The statistics of crimes in the years during which mandatory sentencing has been extended and been effective show that it's only been steadily rising, and we haven't seen a decrease in crime. Furthermore, we've seen mandatory sentencing and the provision of substantive and compelling circumstances be manipulated in order to allow rapists and serial murderers to go free. Furthermore, we have reports by the Penal Reform International which suggest that mandatory minimum sentencing does not deter crime.
Counsel, should we look at the rise in crime with serious offenders already behind bars and the crime rate is still on the rise? Other factors such as unemployment, mental health issues. So mental health issues doesn't only affect prisoners, it affects general population. These are also serious factors that promote the rise in crime. Do you agree?
Yes, Justice.
So declaring this legislation invalid might not be the answer to what we're looking for. Would you agree with that?
It might not be the only answer, but we believe that it is one of the correct answers.
Justice Mchana.
Counsel, assuming I'm with you on the concept of Ubuntu that you mentioned earlier, and it's ignored by the mandatory sentencing, what do you make of the societal expectations of justice that the mandatory sentencing seek to meet? And what do you make of Ubuntu in the context of those victims that have suffered indignity at the hands of these offenders?
Thank you for your question, Justice. We do believe that the same backlash of balancing the interests of prisoners and the dignity of prisoners, as well as the dignity of victims of crime, was met within the case of Jesus Kongonyane, which did overturn the death penalty despite public backlash. It is also mentioned that the reason mandatory minimum sentencing is favored is because there is insufficient education on how best to combat crime. And as we have conceded, we do understand the public perception that formal imprisonment will serve to deter crime and to apply victims of crime. But we believe that mandatory minimum sentencing is punitive and retributive in nature, as opposed to deterring crime and truly seeking justice.
Thank you.
Ms. Jaffer, Justice Jaffer.
Counsel, your case is that mandatory sentencing is irrational. That is my understanding of the case. Because it does not serve as a deterrent. And in your case of argument, the case that I have made, once you have spoken to the concept of crime and the deterrence thereof, you highlight how victims and the general public are impacted. You make mention on that 20% of, I think, you say 20% of the people in South Africa feel unsafe working their neighborhoods at night time, daytime. 66% feel unsafe during the night. Now, my question is, if mandatory sentencing, which is a consistent legislation for certain crimes, as mandated by the Act, is done away with, and we accept the alternatives that perhaps you might elaborate on once I'm done with this question. If we then accept that someone commits a crime how would that work? How would rehabilitation deter the next criminal from committing a similar crime?
Thank you, Justice. It is our submission that deterrence is not only for future offenders, but from preventing current offenders from recommitting crime. A large amount of offenders and criminals are people who have been previously convicted of a similar crime. And we believe that rehabilitation goes to the roots of the problem and ensures that all offenders don't become recurring offenders.
So you're saying we remove mandatory sentencing for a reoffending offender. Is that my understanding?
Yes, correct.
I just have one aspect that I'd like your assistance with. So you've brought in Ubuntu, which is a constitutional value. So the Constitution is founded on dignity, the achievement of equality, and the advancement of human rights and freedoms. You're saying, if I understand correctly, that we're departing from the premise that they need to be persuaded with substantial and compelling circumstances, as opposed to just submitting the facts without that premise. And I'm inclined to say that if one departs with the founding values, then your submissions are more persuasive, because the founding values would mean that you start with as a completely dignified human being without any limitations and free. But we have the case that Dodo case, which already indicated that there's this fairness in the trial, so the fairness of the trials will be challenged. What I'm grappling with, and if you can assist me, is that the criminal justice system that we've inherited, it's not really strong on the African value system. So if you look at Kant and like the German philosophy, it would be that it is retributive, meaning it's if you do the crime, you serve the time. So it is individualized and proportional to that individual. If you look at the British philosophers, it has been more that punishment is bad unless it serves the greater good. In that case, it's a deterrent. So the only thing that I can see that is African in our prescribed minimum sentencing is that it was the majority decision from Parliament. So it comes, we cannot say it is in South African legislation, it's our Parliament, it's the democracy, it's the political will that has given us the minimum mandatory sentencing. And yet, that very Parliament, what do I make of the African value of, and the constitutional value of Ubuntu, which has flexibility, which has creativity, and possibly can bring some solution to the issues that we have now, and at least with the mass incarceration that are black men, at least have, a cultural aspect that is closer to the person that is suffering that sentence. So can you see what I'm grappling with? I'm looking at the philosopher Kant, which is German. This is the British philosophy. That's the history of our criminal system. And yet, the average person who would say that, well, de Klerk that was guilty of heinous crimes because of amnesty was walking free. And yet, those individuals now that are imprisoned, if you look at their crime relative to what de Klerk did, they institutionalized the minimum mandatory sentence in the zero-crime prisons, really. So, sitting back, are we really honoring the Constitution? Is this just? Is this humane?
then disagree with your submission and say that we shouldn't start off with the person being human first, and then thereafter allow the judiciary to impose the sentencing that is opposite to the circumstances, because that allows the greatest reign of the Ubuntu and the flexibility and the creativity. And remember, Ubuntu is very new now. It's not yet as developed. And by having a minimum mandatory sentencing, are we not cutting and stopping short of how the potential of it and how it can be developed through judiciary? Because how else would it be developed? It has to be developed through judiciary. So that's what I'm grappling with, and I don't know if you have submissions that can assist with my concern.
Thank you, Justice. With your permission, I will deviate slightly from the content that was set out in our heads of arguments, as this was not explicitly dealt with in our heads of arguments. But the Constitutional Court in the case of Bear did expand on the importance of having customary law from which Ubuntu arises to be seen as living customary law and to not be codified to become official and inapplicable to changing society. One of our issues with management and sentencing is that it was curated in 1997 and was never meant to be a permanent solution, but has just been extended indefinitely with no sufficient revision of the changing values of society. So I do agree with you that the judiciary should be allowed to exercise full creativity and discretion in line with the court's in the decision of Bear, which said that customary law needs to develop as an ongoing matter, as customs change, as traditions change, as values change. So I am with you on that the judiciary must have the discretion to exercise full creativity so that it can imbibe the values of customary law and imbibe the values of Ubuntu rather than coming from a codified legislative point of view, which was curated during the time where South Africa was a very new democracy.
Thank you, Mr. Bakuma. There's nothing that we will look forward to the answer with the respondents of this charge. Thank you, Justice.
Good morning, my justices. May you please the court? My name is.
You may switch your mic on, and you press it when you don't speak.
Good morning, my justices. May you please the court? My name is Discourse. I appear on behalf of the Republication, which is the Victim Alliance, with my learned friend Mr. Lawyer as junior counsel. The question of law answered by the Victim Alliance is whether the death penalty is constitutional or not, and whether the court should declare Section 51 of the Criminal Law Amendment Act invalid. It is the amicus curiae's responsibility to help the court to come up with a just and equitable conclusion. We are appearing in support of the reinstatement of death penalty, and to also show how the court, how it can be the best interest for society and in the best interest of the minor. I will be making submissions on how the death penalty will be in the best interest of the minor in this case, taking into consideration the right to life of which the was infringed for the minor, including the right to freedom of security. My learned friend will be arguing on the death penalty based on the best interest of society. In making those submissions, he'll be stating into consideration Section 12, subsection 1, paragraph C, the right to life and the limitations where it is just and useful. My justices, in no contest is equal, meaning that circumstances surrounding this matter are crucial when making a judgment. The matter in this court involves the murder of a minor who was barely 17. Section 9 of the Children's Act, read with Section 28, subsection 2 of the Constitution, state that the child's best interest is of paramount importance in all matters surrounding the child. In the case of S versus M, at paragraph 15, it states that Section 28 of the Constitution requires that statute must be interpreted and common law must be developed in a manner which favors protecting and advancing the interests of the children. The courts must function in a manner that at all times shows respect to children's rights. Reinforced by Article 3, subsection 1 of the United Nations Conventions of the Rights of the Child, which provides that in all actions concerning children undertaken by court of law, the best interest of the child should be of primary concern. The amicus submits that the best interest of the minor must be considered in this case, because the applicant violated the right to life of the minor. Therefore, this honorable court must make a decision considering the best interest of the minor who was murdered. In the case of Director of Public Prosecutions versus Tabete, paragraph 22, the learned judge stated that any crime that threatens the well-being of society deserves a severe punishment. My justices, the South African police crime statistics provided in the first quarter of 2024 on page 18 of the report show that child murder has been consistently increasing. To this effect, it has increased to 7.2%. We submit that the minimum sentence of 25 years life imprisonment in itself does not deter criminals and is evident in the child murder rates. Supported by Section 12, subsection C of the Constitution, which states that everyone has a right to freedom of security of persons, which includes the rights to be free from all forms of violence from either public or private sources. The amicus curiae suggests that every child and law-abiding citizen deserves a right to live in crime-free South Africa, where those who offend the law and harm their citizens are punished severely by the reinstatement of death penalty. The amicus curiae submits to this honorable court that this honorable court considers the death penalty because restorative justice benefits the perpetrator while undermining the best interest of the minor, as it was applied in Asbestos Directive before it was overturned by the Supreme Court of Appeal to ensure that the best interest of the minors are protected. The death penalty serves three purposes, which is to deter violent crime and prevent the reoccurrence of the crime. Thirdly, to act in the best interest of children to keep them safe from criminals. My justices, restorative justice should not be used to influence the sentencing when serious crimes are committed. Therefore, the court should not rely on the personal circumstances of the offender when reaching its judgment. It must also apply the appropriate sentences to the crime committed, which is to benefit the interest of the criminal justice system, the government, and society in general, and most importantly, the victims. I would like to conclude by stating that the amicus submits that the notion of Ubuntu influences individuals' perceptions of themselves and the place they live in. And in this matter, the amicus submits that perhaps if criminals and perpetrators were aware that they were going to face death penalty, it would deter them from murdering children. I conclude my submissions.
I must compliment you because you had unbinding the nuance fighting away at your suspicions. So I'd like to talk to you about immediate fellow justices if they have anything to say. Is anyone want to engage? A lot of our justices will be wanting to talk to you today. So Justice
interesting submission. When I read the case, I initially thought your case was a support of.
switch to my book is this one. Well, the justice is doing.
So when I read your case, I initially thought that your submissions were in support of the applicant. Now, my understanding is that you want the death penalty to vindicate the fact that Tata acted to fend off an attack on his daughter, resulting in the death of a minor. So your submissions, I'm certain, are in respect of the minor. My question is, since Tata did not have a direct intent to murder the said minor that you are saying
given the death penalty, how do you do the balancing act? Because he himself was defending his minor daughter. What is the balancing act? How does the court deal with that situation? Yes, a minor has passed, but we had a father who had an obligation to protect his daughter and had no intention to kill the minor. What is the balancing act? How do we deal with that situation?
My Justice, we submit that in line with the notion of Ubuntu and humanity, perhaps if Tata was aware of the death penalty, he would have been kinder and it would have not have resulted in the death of our victim if he was aware that there was death penalty in the life. Perhaps he would have pushed our victim to the extent of death.
He didn't have the intention. Let's go back. He did not have the intention. The facts show that he did not have the intention.
My name is Fanabayana Bayola. I'm appearing on behalf of the Victims Alliance, which has been appointed with the amicus curiae in this matter. I am the junior counsel, and my learned friend, Isefo Sokwana, is my senior counsel. My justices, before I start, I would like to say the Victims Alliance would like to make this opening statement that in a society striving for justice, equality, and safeguarding human rights, the best interest of society, or rather public interest, stands as a guiding principle to reach that goal. The aim is not to only protect the vulnerable, but to also build a society where all can strive. My justices, I will be arguing on the best interest of society. Victims Alliance submits that Section 12, subsection 1, paragraph C of the Constitution states that everyone has a right to be free from all kinds of violence, either from public or from private sources. Therefore, this honorable code should consider the best interest into making sure that that right is not infringed. Section 5, subsection 1 of the Criminal Law Amendment Act states that a severe punishment prescribed is the life imprisonment. The amicus submits that provision no longer serves its purpose, as criminals who commit crime go to jail, whereby they all become overcrowded, some are even released on parole. Therefore, by them being released and coming to society, they increase the right of safety of society, because these criminals have criminal records, which makes it hard for them to find jobs. Therefore, they end up re-offending and harming the rights of the society. Also, the statistics shown from the Victims of Crime report 2024 shows that there was an increase in crime rate, especially murder. I would like to back up these reasons with the case of Kamaiko, where the accused was arrested and later released, whom he ended up re-offending. Therefore, the amicus submits that this honorable court should look into that those that are released, they end up harming the society when released back. Therefore, this honorable court should consider the best interest of society. Also, in the Marman case, the learned judge stated that the court should should take measures possible to ensure that they protect society. Therefore, the return of death penalty will be in the best interest of society, as it will set an example to lawbreakers to obey the law, and people's rights will be protected as written in Section 12 of the Constitution. Furthermore, I will argue on the limitation of rights. Section 7, subsection 3, right with Section 36 of the Constitution states that the Bill of Rights may be limited in terms of the law, generally applicable to extend the limitation if it is reasonable or justifiable. The amicus argues on that the abolishment of the death penalty does not reflect the now society as as in prisons, we have overcrowding. Therefore, the amicus is of the view that if the return of death penalty is imposed, it will only be limited to the state, meaning the state is the only one that can limit the right to life. Section 36 states that any right can be limited only if it is reasonable and justifiable. As the amicus submits that the limitation of the right to life is reasonable and justifiable because it prioritizes the safety of law-abiding residents, reduce the strain of criminal law justice system, and send a clear message to those that will potentially offend, and that they know that there will be an impose of the death penalty. Despite this controversy, this approach is in line with the fairness principle and the government's obligation to safeguard the public. From the reasons I've mentioned above, the Victims Alliance submits that the return of the death penalty is constitutional and it will be in the best interest of society. If you please the court, the judges may impose the questions that they have.
Justice Jaffa. Good afternoon, Council. You've touched on Section 36 of the Constitution, which is the limitation clause. Can you just take me through why the mandatory sentences as they are right now are not the less restrictive means to actually touching the purpose that they aim to serve? I am not sure why the death penalty would trump Section 36E in particular, because legislation has come up with a solution that would be in the interest of society as a whole. So a balancing act was taken in S. Makonyana case, and that case is critical with regards to the right to life and pertinently Section 36, how that section finally formed part of the Constitution in 1996. So how is less restrictive means not achieved by the Act in relation to the mandatory sentencing as they are at the moment?
Thank you, my Justice, for the question. Section 51, or rather the Criminal Law Amendment Act, states that the most severe sentence is life imprisonment. The amicus argues that those that commit crimes, or rather criminals, they risk, or they put their lives, or rather they're at risk of infringing the rights of society. Therefore, if the rights of the criminals are limited, such as the right to life, and therefore the state, or rather the society, will live in a crime-free zone, because those that break the law will fear in committing any crimes. And also, the amicus also submits that in the S. Makonyana case, it does not reflect the now society whereby in prisons we deal with the overcrowding.
Thank you.
Justice Martin.
Council, you spoke about Section 12(1)(c) and violence. The public must be free of all forms of violence. But would you also agree that prisoners, convicted criminals, must also be free from violence? So, criminals infringe the rights of society, their constitutional rights. If they are incarcerated, some of their rights are also infringed. if the death penalty is imposed, a very important right, which is the right to life, is infringed. So, if one tries to balance these rights, what makes the rights of the public more important than that of a criminal or a prisoner who is also part of the public?
Thank you, my Justice, for the question. Section 2, subsection 1, purpose states that everyone has the right to be free from all kinds of violence. But the amicus here submits that if the state would look into limiting the right to life of prisoner, or rather those that commit crime, would be safeguarding the rights of society, to ensuring that society is not harmed in any manner, and that the best interests of society are looked so that we live in a crime-free zone.
Now, Council, would you agree the Constitution is basically the will and the wishes of the people? And the Constitution says, the people say, that the right to life is non-derogable. So on what basis are you requesting that this right be limited?
I'm requesting, my Justice, on the basis that it should only be the state which is only allowed to limit that right to life, not the public, not the citizens, if I may put it in that phrase.
But prisoners are part of the public. The right applies to them as well. So on what basis do you want to limit that right?
I want to limit that right, my Justice, into ensuring that no citizen can infringe the right to life of other citizens, but the state can impose the limitation of that right to life.
Okay, I'm just going to ask you one final question. That didn't satisfy my question, but I will move on. With regard to an accused being sentenced to life imprisonment or any other sentence, would you agree that a magistrate or a judge can be wrong in his or her decision? Would you agree that a magistrate can be wrong, or judge can be wrong in convicting an accused?
Yes, my Justice, that.
And would you agree that there are appeal procedures in place?
Yes, my Justice.
And would you agree if an accused does not exercise his justice? I don't think we cross-examine here. If an accused does not exercise his right to appeal, and if he was wrongly convicted, would you agree that he would be wrongly executed?
Yes, I would agree on that, my Justice.
Thank you.
Mr. Speaker, thank you for your submissions. We look forward to the submissions now, the respondents from the Council. Thank you, Mr. Speaker.
Thank you, my Justice.
Greetings, my Justices. My name is Innocent here. I'm a Buddha and I'm Senior Counsel for the Respondent. May it please the Court, as the applicants have already stated, this matter concerns the constitution balance the rights protected under Section 12 of the Constitution with the legitimate government objective of ensuring consistent and proportionate sentencing for serious crimes. My Justices, I will make the following submissions. The minimum sentencing provisions are consistent with Section 12 of the Constitution, and they are supported by binding precedent, which include the Constitutional Court's decisions in State v. Dodo, in State v. Tuguda, and State v. Masindi. The minimum sentencing provisions serve a legitimate government purpose in deterring crime and ensuring proportional justice, and that there is insufficient and circumstantial evidence in prison overcrowding submitted by the applicants. If I may proceed, my Justices, the applicants argue that the material facts in this case differ from those in previous cases and those in State v. Dodo, and therefore rendering the precedent inapplicable. This assertion is not only misunderstanding the principles of state decisis or the doctrine of the Constitutional Court's decision in State v. Dodo and related cases, where in Dodo, the court held that minimum sentences do not violate the right to freedom if judicial discretion remains, which Section 51 in subsection 3 provides through substantial and compelling circumstances test. While the applicant argues new evidence of overcrowding and crime rates, these factors do not alter the binding nature of the Constitutional Court's prior rulings, and until overturned, the decisions remain authoritative. The applicants also in paragraph 14 of their heads contend that mandatory sentencing directly results in overcrowding. And there is no direct evidence, as they referenced or evidenced the statistics of the Judicial Inspectorate for Correctional Services, and which evidence is circumstantial because it does not directly prove that the prison population is the sole or primary cause of health issues and other conditions in prison. What it does is merely suggest a correlation that requires further inference. The applicants also assert that mandatory sentencing directly contributes to overcrowding, which factors could even be independently, they could independently contribute to the observed outcomes without tying them to Section 51 of the Criminal Law Amendment Act. For instance, systematic issues within the criminal justice, such as social reintegration strategies and rehabilitation, can significantly impact inmate health and recidivism. Mandatory minimum sentences remains objectively rational because they fulfill the legitimate aim of proportional justice for serious crimes, and the challenge of overcrowding should be addressed through other mechanisms.
Ms. Buddha, I think we've reached our time limit. We have had the benefit of your argument. May we engage with you at this juncture?
Yes, Justice.
Thank you.
But can I just say something? I think it was just 3 minutes for now, was it?
You need to look at the timekeeper.
Oh, the timekeeper is
Ms. Buddha, my absolute apologies. You have 3 minutes.
Thank you, Justice. Thank you. The applicant also contends that crime has not decreased despite mandatory minimum sentences. However, the purpose of the provision is not solely to eliminate crime, but to ensure that those who commit serious crimes, as those in Schedule 2, which are crimes like murder and serious crimes, are proportionately sanctioned, thereby reinforcing societal values of justice. Also, the government has a constitutional obligation to protect its citizens and ensure public order. Minimum sentencing not only seeks to eliminate crime, but provides proportionality, which is consistent application of our law, as well as predictability and fairness in sentencing, which are critical to maintaining public confidence in the justice system. So even if this court finds that Section 51 limits Section 12 rights, the limitation is reasonable and justifiable under Section 36 of the Constitution. The minimum sentencing provisions serve the pressing societal interest of deterring serious crimes and ensuring public safety. Section 51's intent in enacting these provisions was to address rising crime rates and uphold justice by ensuring consistent punishment for grave offences. my justices, to conclude, I would like, the respondent respectfully submits that the High Court's declaration of Section 51 as unconstitutional was erroneous. The minimum sentencing provisions are consistent with the Constitution. They serve a legitimate purpose in deterring crime, and they ensure proportional justice and are supported by binding precedent. Thank you, Mr. Justice.
Ms. Kuda, I appreciated the submissions because you did address one of my material concerns. Because my material concern was whether this public power, which is manifest in the mandatory minimum sentencing, is national. And I have the concern because we have the escalation in crime. And your submissions have indicated that it's not only the escalation of crime and the deterrence that is a consideration, it is also that there's uniformity in sentencing. Now let's engage with that link, the uniformity of sentencing. But treating everyone equally and having them sentenced in terms of the minimum prescribed legislation, isn't that per se dehumanizing? Because we're treating everyone in terms of formal equality and not substantive equality, because we need to look into the fact that everyone is different. So we all know what substantive equality is, and the whole fight has always been. We know what the fight has always been. If everybody is treated equally, formally, in terms of the letter of what equal is, that's not sufficient. We need to get substantive equality. You need to go into the thrust of history of the individual. So by having the prescribed minimum legislative mandatory sentencing, are we then not dehumanizing the individual by not looking into the circumstances and having the freedom to look into the substantive equality of that being? Because everybody comes with their own history and the individuality and the humanity and the dignity of that individual.
My Justice. So the question is, are the mandatory sentencing provisions dehumanizing citizens who get arrested?
By treating everybody equally on a formal basis, but not equally in terms of deeper insight, substantively.
My Justices, that is a question that could be answered by Section 51, subsection 3 of this legislation. So basically, what Section 51, subsection 3 provides for is the substantive and circumstantial test, which every person is subject to. Our law applies generally, and if you are being sentenced, the courts have the discretion to consider the substantial and circumstances of you as an individual, and also consider the act in its own.
That's quite attractive, that the Malchus appellate authority on what is substantial and complex circumstances also affords the court of that discretion, but we know that that's beyond the norm. It doesn't look into ordinary circumstances. So if the person's a first-time offender, there needs to be much more. So is that where we should be? Do we not want to individualize the sentencing and allow the court more discretion so that the court can take into account Section 9, which is the right to equality, and that when we look at individuals, we understand that in South Africa, with our history, we certainly have never had the equality, and that we are aspiring thereto for many. And that is why we simply don't say that a generalized legislation applies equally. We need to look into the substance of it. So why is that not similarly applicable? And your answer has been that, well, the court does have discretion on the substantive and compelling circumstances. But he said, is that not going too far? Should we not be better than that?
My Justice, the respondent does not argue that we can better the law. We can better the law, but it does not mean that we should be striking Section 51 or declaring it inconsistent with Section 12.
I must say I'm really impressed with your submissions, because what it possibly means is then this court can interrogate and further advance what substantive and compelling circumstances may be. And substantive and compelling circumstances certainly can take into account the history of our colonization and that impact. So perhaps, well, it's food for thought. So I must say that I am certainly impressed with your submissions. Thank you.
Thank you, Justice.
Ms. Johnson has questions.
Quick question. The applicant has gone to task with highlighting the concept of Ubuntu. As Section 51 stands, would you submit that the ideals of Ubuntu are reflected in that section? If they are not, if your submission would be they are not, how then would the respondents attempt to remedy that issue of the section not being compliant with the ideals of Ubuntu?
May I ask you to please repeat the first part of your question? The first question.
No, it's only one question. It's only one question. The question is, do you think this section as it stands, has it factored in or has it considered the ideals of Ubuntu? Or is that something that still needs to be done? If it has to be done, if you submit that it has to be done, how then the respondents do that?
My Justice, Section 51 does not impose blanket sentences, if I may put it like that. What it does, it also provides for proportional sentences for proportional crimes. For instance, a first-time offender will not be sentenced in the same way as a third-time offender would, or someone who's committed murder would be. So it does incorporate the principles of Ubuntu in the sense that it considers a person for who they are, and also the fact that the purposes of the Criminal Amendment Act is not just putting people in prison. It incorporates consistency, proportionality, and it takes into account rehabilitation and all that is covered by the law. So I wouldn't say that this section excludes Ubuntu, or it doesn't take into consideration the values and the principles of Ubuntu.
Thank you.
Yes. Justice Naidu.
Counsel, considering the facts
Justice, from the Court of Law, Tanda fails to prove substantive and compelling circumstances in his case. So I would say the Court of Law, the court was correct in giving him the sentence. Unless he can provide the court with substantive and compelling circumstances and give the court the platform to explore that, to express or to apply its discretion when it comes to Section 51 subsection 3, then perhaps the decision could be clear.
Looking at the facts of the case, would you say that substantial and compelling circumstances have been placed on record?
Please repeat the question.
Looking at the facts of the case, would you say that substantial and compelling circumstances have been placed on record? That there are substantial and compelling circumstances in Tanda's case?
Yes, Your Justice, I would say there are substantial and compelling circumstances in Tanda's case. Thank you, Your Justice.
Ms. Buddha? Ms. Buddha, thank you so much for your submissions. We look forward to the submissions of your training.
Thank you.
It's Ms. Madadzikana.
You can say Tabonga or name them.
No, Mr. Madadzikana.
Maradziki.
Maradziki.
Yes.
Mr. Maradziki. We're not on first name basis.
Alright, Maradziki. Good afternoon, my justices. As it pleases the court, I am the junior counsel for the respondents, and I will be making a submission on how mandatory sentences do not frustrate the purposes of the Correctional Services Act, also taking into account Ubuntu, restorative justice, and the objectives of the Correctional Services Act. At this juncture, I would like to direct the bench to the respondent's set of arguments, paragraph 27. In the Ndumeni case, heard in the Supreme Court of Appeal, it was held that when we look at an act and we want to decide whether it's constitutional or not, the point of departure is firstly understanding the purpose of the act. Crime is a public wrong, meaning it affects the public. This ideal emanates from notions of Ubuntu, which states, for example, I am because you are. That's how a certain individual, just one individual is affected. It means the public becomes affected as well. This then justifies one of the purposes of the sentence as laid out in the S versus Kula case, where it was said that interests of the public should be presented or represented rather. The public has an interest that each crime should be met with a proportional response, taking into account the severity of the crime. This is also consistent with what this constitutional court held in the Dodo case in paragraphs 26 to 31, where proportionality was emphasized. Its importance is large. The first importance is taking into account that prior to where we are today, South Africa was an apartheid state. And during apartheid, judges' discretion was not limited. Thus, proportionality was not achieved. What one judge would judge in this case, even though the case is similar there, a judge would judge differently. So, now, the mandatory sentences have been constructed in a way that uniformity, as the senior counsel for the respondents explained, should be achieved to reflect also that right now South Africa is now a constitutional supremacy state where the constitutional takes precedence. However, now we have established the purpose of the mandatory sentences. Their continuing existence now is based on how it relates, or how they relate to Section 12 of the Constitution, which is also in question today. This is because the sentences do affect freedom. Section 36 of the Constitution provides that rights can be limited if the limitation, as the amicus curiae explained, is reasonable and justifiable. Now, the extent to, or rather one of the factors that is considered when a right is being limited is the extent of the limitation. The extent to how or to when the Section 12 right can be limited is stated in that right itself. The limitation should not reach the grounds that are cruel, degrading, and inhuman. It's also consistent with what this court again held in Dodo at paragraph 35, where also it looked at the Mapanyani case and it said that where the limitation does not reach cruel, inhuman, and degrading grounds, there is a just cause for the limitation of Section 12. A crime like murder should be made with an appropriate response, which would be life imprisonment. Because murder is a violation to one's human rights, life imprisonment becomes appropriate. Now, as far as restorative justice is concerned, and Ubuntu, as a goal of sentencing, it is reflected indeed in the mandatory sentences. The bench directed questions to the senior counsel asking if Ubuntu restorative justice are reflected in the mandatory sentences, and the respondent submits yes. Firstly, the sentences allow adequate time within which one offender is detained. They can be rehabilitated and exposed to programs that help them be integrated into society. And also this gives them an opportunity to be released on parole. For example, Section 48 of the Criminal Law Amendment Act allows those facing life imprisonment to be released after 25 years if they show that they are people who are now socially responsible. Thus, mandatory sentences do, in this way, meet the objectives of the Correctional Services Act, which also are Ubuntu. Now, if this court decides to confirm the declaration, the just and equitable order would be to allow the sentences to be reviewed, but the court should consider that not all those sentences that are reviewed would lead to the people being released. Only those who have demonstrated good behavior and social responsibility during the time in which they were incarcerated should be released. To answer the question of the death penalty that was talked about, was stated by the amicus curiae, Section 34 of the Constitution provides that everyone has the right to access the court. Secondly, Rule 10 of the rules of the Constitutional Court provide that for an amicus curiae to be admitted, they must have an adequate interest in the matter. The Victims Alliance, they do have an adequate interest. Their interest is in the deterrence of crime, and crime being made with a proportional response, just as the respondents are submitting today. However, although they do have the right to make submissions as they have done so, the sentencing committee should be slow to consider all the submissions because the amicus curiae objective of leading the court to a just and equitable order cannot be achieved where they require or where they submit that the death penalty should be fostered or brought back. It was really declared unconstitutional because it infringes on one's right to life. And in the SSS Mapanyani case, it was held that infringing on one's right to life is an infringement on all other rights. All other rights become terminated when the right to life is taken away. In terms of the order, of course, if it pleases the court.
Could you please wrap up?
Yes, thank you. In terms of the order, of course, we do agree with the applicants that the biology principle should be applied to foster Section 34 of the Constitution, which guarantees the right to access the court. The prayers are as follows. The respondent graciously prays to this honorable court, my justices, that it dismisses the application and does not confirm the declaration by the High Court. Once it does so, the case should be returned to the Polokwane High Court. As an alternative, to have those who have demonstrated good behavior as asserted and social responsibility to be released. And lastly, to make an order of course in terms of the bywatch principle, just as the applicants also submitted. Thank you, my Justice.
Justice Mutana.
Thank you, Councillor Makaziki. Am I calling it right? Council, what do you make of the non-derogable nature of Section 12, in particular 1D and E? And I'm asking on the basis of the contention made by the applicant that overcrowding is tantamount to torture and subjecting one to inhuman condition. What do you make of the mandatory sentencing militating against Section 12, 1D and E?
To start with, my Justice, the respondent would like to submit that although Section 12 is a non-derogable right, firstly, it was also explained by those who came here that rights have to be balanced. Yes, the prisoners have a right, Section 12, for freedom, security, not to be treated in an inhuman way, but that right also comes into question when they have committed an offense, and now the rights of the victims also are in question. And in terms of overcrowding, according to the South African government, the information and services, measures like electronic monitoring, special remission of sentences, and halfway houses, these measures have been taken to deal with overcrowding. However, yes, currently still the overcrowding exists, but this court should consider that these socio-economic rights that the prisoners are entitled to cannot be realized immediately, but rather are progressively realized. So, while overcrowding exists, measures are currently being taken by the government executive to deal with that, and it becomes a progressively realized right.
If I went to you, Councillor Makaziki, are you inferring that Section 36 can be applied to this non-derogable right? Is that what you are proposing?
My Justice, rather what the respondent would like to phrase it as is that Section 36 should come into question, particularly where people have limited other rights of other people by engaging in crime.
Thank you.
Justice Adams.
Council, just want to get your, what is your solution on the sentence that was imposed by the court on this matter? Would something as creative as that not serve society and would do better than a mandatory 1%?
My Justice, to start answering the question, I would like to submit that crime should be looked at, or how we respond to crime should be looked at holistically. So it's not only that we should only consider certain substantial and compelling circumstances, that's all we should consider, or that the circumstances should not be considered, the mandatory sentence should be considered, or that overcrowding alone is a problem, so the whole system should be taken away. Instead, mandatory sentences, they do allow for, they exist mandatory sentences, and they're important, I've elaborated on it, but it also does allow for the creative nature that you have explained to exist. It's For example, in the SABWiL case, it says that the mandatory sentences exist, but where there are compelling circumstances, they can be deviated from. So, yeah, the respondent had to make that submission.
So if I get you correctly, you're saying that the creative sentencing or the protocol can be covered by the substantial and compelling circumstances anyway. Is that your submission?
Please rephrase your question.
What is your response to my question then, that the creative type of sentencing that was handed down by the protocol as matter can still be done under substantial and compelling circumstances?
Yes.
Okay, and then just one final question. It's not a question, it's just confirmation. So you are opposing the amicus curiae's submissions on the death penalty?
Yes, the court should be very, very slow to consider those submissions.
Thank you.
Your lead counsel persuaded me about one element of the purpose, and that was the deterrence aspect was not the only purpose. So, and that even if crime is increasing, I certainly am not persuaded that it is deterring better than the prescribed mandatory sentencing is not deterring crime. So then the counsel continued and said, well, there's another purpose, that's uniformity. Having heard your submissions, I would like you to appease a critical concern I have now. Is this uniformity that is one of the reasons that everybody is having a standard sentence for a crime? Is the judicial discretion not less restrictive means as opposed to having the legislative option? And isn't that the solution? Because the judicial discretion is less restrictive as opposed to having the mandatory minimum sentencing, which is the legislation. And the judicial discretion also incorporates the creativity and can develop the Ubuntu aspect, which is sorely needed in order to imbue our common law with African values.
My Justice, allow me to answer your question in different parts. There were different parts that I answered from the question. To start with, the bench is aware that the death penalty was refabricated, and what came out of the death penalty is life imprisonment. That is, as the respondent likes to believe, and I said, the most severe punishment that can be imposed on crimes such as murder. Right? Now, what then happens now is that, as also you reiterated, sentences have different objectives, and the objectives include proportionality, as explained, and life imprisonment already covers that. And now, in terms of how less restrictive, you're saying that if mandatory sentences are abrogated, the judges can have discretion, which is less restrictive, right? However, it can happen that in this case, the judges exercise discretion, which is less restrictive than what a mandatory sentence imposes, right? But firstly, that also becomes a violation, or rather, it becomes an infringement on objectives of the mandatory sentences. And also secondly, it creates a situation where in that other case, because your discretion is not controlled, there are no parameters within which you can work with, except for the compelling circumstances. In another case, your discretion might be overboard, right, if I allow you to put it that way, which then leads to my last aspect in answering your question. It infringes Section 34 of the Constitution, right, which says that everyone has a right to a fair public hearing. So the idea of fair cannot be achieved where these mandatory sentences are not there, because it creates the uniformity and the equality that we need in the criminal prosecution phases.
When I indicated less restrictive means to achieve the purpose, I intended that the judicial sentence is the less restrictive means, regardless of whether the sentence is higher or lower. Are we understanding it?
Right, please rephrase.
So, if we are limiting rights, then we take into account the nature of the right, the purpose of the limitation, the relationship between the nature of the right and the purpose, and also are there less restrictive means to achieve this purpose, as opposed to having legislation. So isn't the less restrictive means that's achieving this purpose the fact that the judiciary can grant a sentence? Because remember, you have a limitation of rights, so we only impose the legislation if there's no other less restrictive means. So isn't the solution that you can achieve the purpose of the Correctional Services Act, and the less restrictive means is to allow the judiciary then to sentence based on what the facts are, the aggravating and mitigating circumstances, taking into account the relevant factors. Isn't that the less restrictive means?
That would be the least restrictive means.
And isn't that a means that affords the judiciary the opportunity to bring in that creative element of Ubuntu, and then for counsel, the submissions from counsel for the parties, to assist the judiciary on how to develop the concept of Ubuntu in criminal jurisprudence, because it's sorely lacking.
Right, just to understand your question, you're saying that having mandatory sentences done away with would mean that instead we can have a less restrictive means, which would be for the judiciary to have discretion which is unfettered, so that they can have a creative way of approaching each crime.
We understand each other very well. Yes.
All right, thank you so much for elaborating that. Yes, it's important that in each case, a less restrictive, like Section 36 fosters or puts forward, a less restrictive means should be achieved, right? And also to foster the values of Ubuntu, creativity of the judges should be allowed. And it is allowed in the mandatory sentences. It's genuinely, this senior counsel reiterated that Section 51, subsection 3 allows an inference or move away from the mandatory sentences where there's a look at the substantial compelling circumstances of that certain case. So the goal, as I'm establishing in the question, is that we need to have a creative look at each case, and that creative look at each case is there, as explained.
Yes. Legislation is interpreted in terms of its ordinary grammatical meaning, and Just the grammar, substantial, it's compelling. Does that resonate with creative? And Ubuntu?
Just ask me a question one more time, please.
Does the words, the ordinary grammatical meaning of what is substantial and the ordinary grammatical meaning compelling? Listen to the word substantial. It's substantial and it's compelling. Do those words resonate with the word creative? And Ubuntu? Maybe it does, maybe it doesn't. What is your solution? I don't think it does. Because you are submitting that that's where you bring Ubuntu. Substantial, compelling. Substantial and compelling is dark. It's got a certain meaning. It must be. It's not light and creative. It doesn't bring you freedom. It's standard. Just the ordinary grammar. So how can you bring in Ubuntu and creativity to it? It's substantial compelling. It is very narrow. It gives you. It doesn't give you that creativity and discretion that Ubuntu and creativity allows.
Ubuntu will not come only where there's substantial and compelling circumstances. Even before having substantial and compelling circumstances, Ubuntu, just as I explained my argument, is already there. Restorative justice is the goal of the mandatory sentences, like how explained that the people who...
Okay, Mr. Anatike, we know, we've already indicated to you that I'm not persuaded that it's a deterrent. So we know, we looked at the GIS report. So our prisons increase crime. Our prisons don't rehabilitate. So there's nothing that's able to do for us that our prisons pass muster in terms of restorative justice. That's the problem. The only amenability I had to the respondents' document was on the uniformity. Having considered the uniformity and taking into account equality in the history of colonization and that we are so different and we need substantive equality, I certainly am not amenable to uniformity being achieved through the mandatory minimum sentence.
Was there a question or just a comment?
Would you like to persuade me otherwise?
Yes, if you please raise this question, I'd like to try to persuade otherwise.
Your persistence is commendable. The mandatory minimum sentencing has a discretion, but that discretion is a compelling discretion. It must be substantial. So the mere word substantial and compelling are restrictive. It's not aligned to creativity, flexibility. It's not aligned to Ubuntu. It's narrow. So clearly, Ubuntu is not manifest in the mandatory minimum sentencing. African values is not manifest in minimum mandatory sentencing, except through the fact that it's democratic. So the only thing that one could say is African about the minimum mandatory sentencing is that it was made post-apartheid and not in colonized structure. But one needs to take into account that it was made as an intervention. It was never intended to be perpetual. And it was an answer to the call of the abolition of the death penalty. So I have wanted to be persuaded that it's still fit for purpose. I'm not persuaded it's fit for purpose on the basis that it's a deterrent, because it's not. Everyone here knows that crime is increasing. We all need to be vigilant and careful. not a way that South Africans should live. We need not live in a country where we need to fear for our lives. And we, as lawyers, have a responsibility to improve the criminal justice system. You are making submissions to the highest court in the land. And if that mandatory minimum sentence is simply there to appease the political will and create a false hope, then we shouldn't pandy to that false hope. We should, without fear, declare it unconstitutional and then open up better ways. And if there are no better ways from Parliament, then the judiciary has the ability to impose the sentencing on an unfettered basis to develop the common law in line with African values. And that doesn't stop Parliament from passing legislation that is fit for us. So if there's nothing further, I have no further questions, but that's what's culminating from me having heard all the arguments to date.
The court allowed me to try and take the job at their own time.
And that is my invitation to you.
Right. So one of the ways we can look at Ubuntu is that we are one and we should live in harmony. And living in harmony would also mean that when an offender or someone engages in crime, that crime should be punished in a way that is appropriate so that they do not come back and infringe on the values of the community and harm the community. Right? So how mandatory sentences achieve this objective of Ubuntu is that each crime is met with a response. Okay, when a crime is grave in its nature and it's a serious violation, it's met adequately also with a sentence that is serious to deal with that, so that that harm, that the future harm that also could be imposed, or rather the harm that has been imposed on the community can be reflected.
Mr. Manzi, your submissions are interesting. I appreciate your submissions. And they're now culminating in questions from Justice Nunn. So.
Council, I have two questions. One more for you to confirm. If I understand you correctly, what you are saying is that the minimum sentencing legislation provides a benchmark for fair sentencing. Is that what you conveyed?
Yes.
Thank you. Secondly, with regard to, you summarized what Chief Justice said very nicely. I'm sure that you understood what was required of you. But I want to know, if judicial discretion is exercised in an unfettered way, what are the risks of such unfettered discretion in this moment that we find ourselves in today? The risks. Are there any risks? And if there are, address us on what are the risks.
So one of the most obvious risks by justice is that a crime that, if the discretion of judges is unfettered, there would be no correlation between how one crime, similar crimes are sentenced by different judges. Also considering that, like you say, in this climate, we are in the digital era where we are exposed also to the values from different communities, which in a way affects the judicial activism of each judge. So it then means that where the judge's discretion is not unfettered, it becomes based on their own thinking and their own outlook And it could also reflect a society from, for example, Finland or the United States, and not currently reflect the society of South Africa. Also taking into consideration that Justice Langer said in his article, Transformative Constitutionalism, there is a need for judges to ensure that equity is represented right now, to giving value to the values, giving effect to the values of the Constitution, because we need to progressively keep moving, and he said there's no end to this movement, progressively keep moving to a place where what happened in the apartheid era is completely fixed. And what used to happen in the apartheid era is that there was this unvetted discretion, and it led to unfairness.
Thank you. Any other risks that you can think of? So there's no correlation in sentencing of similar crimes. We want to get rid of what we were exposed to in the apartheid era, and other cultures now come into our arena. Is there anything else you'd like to address as well?
No, my justice.
It's okay.
Mr. Malibongwe, thank you very much for your submissions. They were stunning. I look forward to that applicant's reply.
Thank you.
Good morning, my justices. I just want to reply to the ordinance argument about how in the past, in apartheid, judges were free to make decisions as they wished. But I would like to contradict that. In the times of apartheid, we know that the judges were doing the will of Parliament. They were following what the legislation was telling them to do. They were not allowed to go against the legislation. They had to follow the formalistic approach to justice as opposed to the creativeness of judiciary. They didn't have that freedom to respond to injustices. They had to do what the will of Parliament was. They had to do what the legislation told them to do. Other argument I would like to contradict is that my learned friend, he mentioned how it is proportional, or proportionality plays rather an important role in mandatory minimum sentencing, and it is not so. Rather, minimum sentencing upholds consistency as opposed to the proportionality. We applicants argue that rule of law requires fairness and proportionality as opposed to consistency, and blanket approach to each and every case. For example, my justices, just a silly example of I bought a house. That house has non-standard windows. I'm going to buy my windows for that. I buy my curtains for the windows that are there for Mr. Price, the standard windows. It's not going to serve its purpose of covering the window. It requires particular size. It requires particular fitting. I rather need to ask someone to sew curtains for me for that window that will serve its purpose. In a similar way, we argue that each and every case must be treated differently, not predetermined by the predetermined criteria that minimum sentencing is offering us. That's not going to serve justice. We cannot be blinded by having one-size-fits-all legislation. We need to have justice. We can't repeat the past injustices. Also, with regards to Ubuntu, my justices, applicants argue that punishment and restorative justice are not mutually exclusive. Ubuntu does not override punishment. It ensures punishment is fair, proportionate, and aimed at achieving justice for all stakeholders. The principles of Ubuntu and restorative justice do not call for absence of punishment. We're not saying don't punish criminals or murderers. We're rather saying that we need to look at other alternatives that might serve the purpose of rehabilitation of those people like our applicant who is not a threat to society, and he would have been better being productive and rather contributing in a good way to society as opposed to being in prison in crowded situation. My justices, it's very similar to, let's say we take a principle in delict law. Courts are moving away from monetary compensation that is imposed by common law. For example, if defamation cases arises, which one serves better purpose? An apology, which is part of restorative justice, or the monetary compensation. So there are places we need to think of to introduce restorative justice alternatives as opposed to retribution, as opposed to something that doesn't really serve its purpose. And that's why we would like to uphold the High Court's decision and declare Section 51, Subsection 1 unconstitutional as it doesn't serve its purpose as it's supposed to be serving in its nature. Thank you.
Ms. Roger, since you've answered all the questions in your submission, so I want to take this opportunity to thank Council. There's one more question. Just as now, do we like to thank?
Considering that we are dealing with very serious offences, what do you suggest are suitable alternatives for such serious offences?
Thank you, Justice. We in our submission mentioned there are some alternative remedies, or not remedies, the methods. For example, one of the methods can be parole, earlier parole situations where people like Tata can go to on parole earlier. However, the current legislation doesn't allow that. You have to be at least 25 years in prison before your case can be considered on parole. So maybe earlier parole cases for people who do not present a threat to society can be catered for. However, I agree with Chief Justice, fully agree that perhaps judiciary can play the role as an alternative to bring justice to particular situations. We believe that judiciary has that sentencing role, the power. It understands, it hears both parties. It understands particular situations of the person. There is evidence in front of them. The judiciary hears both sides, the respondents, the applicants. The amicus curiae also plays an assistant job to the judiciary. So I think judiciary can be an alternative as opposed to the legislature imposing something that doesn't work in practice.
Would you agree in Tauter's case, he was sentenced to effective 1 year imprisonment?
Yes, my justice.
So the minimum sentence legislation was used in a creative way to minimize his sentence drastically. So the court,
Justice, to understand correctly, the court didn't prescribe a minimum sentence in that case.
The court didn't prescribe a minimum sentence, but exercised a discretion to impose a lesser sentence.
My justices, the current matter did not cater or didn't fall in the box of compelling and substantial circumstances. So the Tata's case wasn't really in that category. It's hard to prove in practice those substantive and compelling circumstances. Thus, it doesn't apply in this matter.
Okay, let's leave it at that. Thank you.
I simply wanted to throw this out, but it's not really that applicable to this suit. And I think for these circumstances, it's important for us to be aware of it and have it percolate. You see, where the political will has come into play in this particular circumstances is through a statute. So the political will in Parliament and the public have appealed through a statute. The judiciary already has a large discretion. And now we're advocating by doing away with the mandatory minimum sentencing of increasing the judicial discretion until there's another statute or there's an acceptable political way. If we do away with the mandatory minimum sentencing legislation. And if you look at the discretion of the judiciary, we've moved away from a jury system. And a jury system is to bring in the voice of the public and allow the public to be more involved in whether the person is acquitted or not. So the jury system meant, there's a better there's a democratic voice. So because we've moved away from the jury system, we now have the judiciary and we have acts. The acts speak for the public. And we have this increase in crime. Is there not then, by doing away with the prescribed minimum mandatory sentencing and allowing the judicial voice to speak to the creative element, are we not moving too far away from democracy? And is there a space for a jury system to perhaps assist in this criminal justice regime that clearly South Africa's criminal justice is not dissuading crime?
My Justice, there's a dilemma between Parliament, which represents the will of the people, and there is judiciary, which is independent. The Parliament issues laws, however, and it represents the majority of people as well. However, it happens that not each and every people give their voices to particular legislation. They don't vote. Not all of the people vote for particular legislation. There are some room. Perhaps some other people feel a different way. So the point is that the will of a minority who does not vote for let's say for a legislation, they might think in a different way about a particular bill, for example, before it becomes an act. So while the particular act reflects the majority of people's will in our country, it could be argued that perhaps minority who could not vote for a particular bill would have, their contribution would have been also important, and valuable. So I want to say that the fact that the majority tries to vote for a particular bill does not always happen to be right thing. And it's a combination of a political will and also other things also play a role for the bill to come into an act. And also the nature of minimum sentencing was 2 years in the beginning and has been extending and expanding up until 2007. So that a reluctance from Parliament to explore better alternatives poses questions whether the majority really wanted to carry on having that legislation into place. It questions the validity of it questions whether the majority really wanted that, the act. And we see down the line in 2024, we see that crime has been increasing, like you mentioned, my justices, that deterrence only doesn't serve its purpose. We need to look into the alternatives and call for a different act, a different bill. And elsewhere, we look into judiciary's discretionary power that it's valuable to public as well. Thank you.
Ms. Rodder and all the council participating in this matter, I'd like to thank you on behalf of all of us for excellent preparation and very impressive heads of argument, as well as other submissions. So it has been exceptionally informative and useful to all of us. We will, in the interest of time, deal with our judgment at this juncture. And then, after our judgment, we'll adjourn for 15 minutes in order to deliberate on the awards. So, you may take your seat, Ms. Rodder. Thank you. Our judgment is we will reserve judgment. And our judgment will be a feedback session. Because this is a training court. So we won't speak. You've heard our questions, so you have a clear idea of what each justice thinks and what our view is on the outcome. But these are topical questions, and they may very well be in front of this court, and they may very well be a decided decision by a constitutional court on these very matters. So watch the space. But this is a training court, so our judgment predominantly is a feedback session. The justices here today all have extensive experience in litigation. We are advocates. So you are going to have input from all of us on your performance today, and in the hope of improving. And that is going to be the content of our judgment. So what I will do is then I'll open up to the rest of the justices to speak individually or collectively on how we can be better or continue as we are. Justices? This is a feedback session, so it is really up to you on what you take from it. Justice Jagger wishes to add a voice to the feedback session.
I've got a few pointers for all of you. The first pointer is to Igama. I was very impressed with all the attorneys. They were all well prepared, very confident, When you presented your cases, you were very confident. Obviously, there's confidence issues that you need to deal with. We still struggle with the same things. But what I know about nerves is that they will always push you. So it's hard being on the other side of the mic, trying to persuade a court, but you were all brilliant. You did your best. And obviously, you never know what the judge is going to ask you. So you have to think fast on your feet, but you stellar performance from everyone. I like that you all knew your cases. Junior counsel for the applicants, I liked how you referred in most of the case, in most of the submissions that you made, literally top of your head, you referred to cases. You just, in this case, this was it, right? Justice Lama, brilliant. That means you were well read, well prepared. That just shows it comes through. Well spoken as well. Love that about you. The amicus team. The only feedback, perhaps a negative, when you stood up to speak initially, senior counsel, you were very confident. You just faltered a bit once we started posing questions to you. And the only reason I suspect that happened is because your case, you narrowed in on your case. You narrowed in on a certain point. You stuck to that point. You did not play devil's advocate when you were writing your case. So when you write your affidavits, when you draft, once you practice, when you draft, you have to anticipate what does the court think about this? What are the possible questions that the court might ask? What are the other parties? What could they possibly say? So you anticipate all of that. So when you come in with your point, you can then just fire back when people are not understanding of your point of view. But other than that, other than the fact that you really zoned yourself in on one point and did not try and look at everything holistically, your presentation was brilliant. So just be mindful in the future that you absolutely have to play devil's advocate all the time, especially if you want to be in practice, because there was all. And then, with reference to the respondents, honestly, I can't fault anything. Heads well done, presentation well done. Young men, persistent, very good orator. I absolutely enjoyed everything I heard from your team. Ordinarily, in real life, you would get a beating because you're from you were representing the respondents, your government just gets a hard time. It does not matter whether they're in the right side of the law or on the other side. Generally, you will get a beating, you will get questions. You saw how Chief Justice was zoning in on you. She just wanted that one little mistake. But listen, you stuck it out, you did so well. Thoroughly impressive. Overall, everyone did phenomenal. One last thing, the applicant's heads of arguments. Your names don't appear on your heads of arguments. So at the bottom, once you've drafted, your names should reflect. Unless I missed it on the second page. I think it wasn't there, yeah. So just small things. The heads of the respondents, your formatting, spacing, but I suspect time, you guys probably come from exams, I don't know what is happening. You're still learning. It's a skill that all of you are gonna get to grasp. My tip with drafting, go on Safi, go on the internet, find documents that have been drafted by seasoned, there's lots on Google. Just find a case that's popular. You'll find heads of argument, so when you draft, just use that standard and then you copy how they draft, the formatting and that. and over time you develop your own style. But other than that, I think once you come into practice, you are good to go. I was so impressed by all of you. And thanks for taking time to actually...
You had a difficult role. We made it even more difficult. But you stood by your argument, you made your submissions, and you stood by it. You made concessions when you needed to, and that was important. You were also very confident. One big criticism: do not row in court. I know you share rows, but rowing must be done outside. So even if you have to take a second to go outside and exchange robes or whatever, never row in court, okay? I think it was Jury Council who said my submission is, my submissions are. That's what we want to do. We don't give opinions, we have submissions. And these are things we learned at a later stage, after making mistakes we made many times. I said I'll come back to the 25 years in life. Till today there's a lot of confusion with regard to that. Life imprisonment is life imprisonment. So it means you're sentenced for the rest of your natural life. You may die in prison. But with life imprisonment, you only qualify for parole after 25 years. So that's what 25 years kicks in. The respondents. Senior counsel for the respondent. Please make sure you use the correct terminology. It's not substantive and comparative circumstances, or substantive and give us another word that you used. It's substantial and comparative. Once you have the right terminology and you understand the right phrases, you will be more confident. It'll just take a judge to pick on a little bit. It'll reduce your confidence in court. It will affect your argument. So know your content. I liked junior counsel who quoted Dodo, paragraphs 26 to 31. That would be very helpful for the judge. When you just say in S versus Dodo, it's a whole other case, and you know with constitutional court cases, they vary. So it helps to refer to the exact paragraph or paragraphs that you want the judges to refer to. And during counsel, you summarized very well. I was very, very impressed. It showed that you had such a good understanding of all the concepts that the judge mentioned. And you, in 3 or 4 lines, you brought everything together very nicely. Just one thing with regard to drafting. The applicants, I see in your heads of argument you refer to paragraph 10 supra. So you're taking the judge back, you're going back in your heads. It becomes a mission to find. So when you make a footnote, even if it's repeated, you put down the case and you can say refer to above. It's fine, you can refer to it above, but also put in your footnote what you're referring to. It makes easy reading. I'm just going to add in one more there with regard to drafting. Make sure you had such good practical experience here. I am so impressed with SABWiL. You're not going to get this anywhere else. And the plus factor for you is you started in the Constitutional Court, where many people...
There was not much that we could actually ask you, because everything was easy for you, but very, very well presented, very well done. And those junior and senior counsel were very, very well prepared. The applicants very much more difficult case. I was very impressed with both. Both senior and junior counsel. Amicus, you had an uphill battle. Both parties were against you, so I'm not surprised that you guys faltered, towards the end. But well done to everybody, and hope to see you in court soon.
Thank you, Justice Adam. Now we do Justice Chana.
Thank you very much. Let me first start by thanking Chief Justice Thierry for the good work and SABWiL for hosting us. This is really a privilege, and I just want to emphasize what my colleagues mentioned when they say it's a privilege. You are doing this litigation in the highest court in the land. Not many practitioners get that privilege to appear in this court. And when I look at you, I see future legal gurus. And I mean it, I'm not simply saying it for the sake of saying it. I mean it. What I witnessed here is passionate young lawyers in the village. Keep it that way. Remember, passion and excellence are inextricably linked. If you're not passionate about your work, it will reflect in the quality of the submission. They normally say the quality of the submissions depend on the level of your preparation. If you prepare more, it will reflect in the quality of the submission. And I will also want to reiterate the words of my sister here, Justice Jan, when she said, when preparing, do not only focus on your version, also try to think about what the other party might raise. It's important, so that you are not caught by surprise when judges ask you questions. Another important point, it's time management. The court does not have the whole thing. It's important to be crisp and succinct in your approach. Try to be brief, but on point. And I think all of you will have realized that you try to manage your time effectively. Keep it up. Another point that I want to raise with the amici team. Your case was the most difficult because you were advocating for death sentence. I was waiting to hear you raise issues like what is happening in other countries where death penalty is applied. So you can give us a comparison and say it's effective in countries where it's used. They have less crime. But all in all, I was impressed with how you stood your ground, although questions were coming left, right, center, but you stood your ground. Because it's not easy to go when the facts are not on your side. You are as good as the facts. Coming to the applicants, I think you had a better case all in all, and you did really well. Just there was a point where the senior counsel, when asked questions, the flow then decreased. But all in all, I'm happy with how you handled the whole litigation. The respondents. So super impressed. Your oratorical cadence was just on another level. The junior for the respondent, I'm happy. Most importantly, and what I've realized from all of you, and which is commendable, is that you kept eye contact. It's important. Even when you read, don't spend 5 minutes looking on the papers or your laptop. Try to make eye contact with the justices, it shows that you really believe in your submission. But if you then look at your laptop for 5 minutes or 10 minutes, it's like you have not prepared enough. But all in all, you are going to make it in this fraternity. Keep it up. There is no alternative to hard work. They can say work smart. Before you work smart, you have to work hard. Those who work smart, they have worked hard. That's why they are able to dissect these cases more effectively. Well done, guys. Thank you.
I have thrown out, is this a court that is something the youth want should be strong because it's a lot of work. And the feedback has been consistently that we should continue doing this work. And when you submit before us today, then it also affirms all the work that we put into it. So it validates that all the time that our justices have volunteered today and the support of our guides and our trainers, it validates that this is something that we are genuinely happy to do, and you have honored our time. So I want to thank you and the justices and the trainers and our guides for coming together to ensure that we have this sterling occasion where you have submitted impeccable documents and it's oral and written. And also a special thank you to our National Executive Committee and our members that have made today possible as clerks and our president and our treasurer and our COO. And because when I read your textbook, I know it's a win because it shifted. So I have, my own perspectives, and when I read, you add, then I know it's win. I don't necessarily agree with the case, but then I know it's impactful because you have mentally moved me, and I have grown with you in this scenario and the set of facts, and we look forward to a constitutional judgment on something of the sort, and that will be very informative. So when I read the heads of government, it certainly left with the impression that you're ready for submissions as counsel. So if you were given a brief, you certainly would do justice to the clients that you represent, and you don't yet even have the admission as an advocate. So very, very well done. It's exceptional. And then when you appear here, the most critical part of any advocate, when they're engaging with the judiciary, is respect. Every single one of you pass muster. So there's no point. How do you persuade if you're not respectful? So who's going to listen to you if you're disrespectful? So from the respect point of view, you certainly all pass muster and excelled it. Now because you've honored us with your very best, I'm going to share with you what was shared with me by a leading senior counsel. And you can take this forward and then build upon it. But before I tell you that, I'll just highlight that. I don't know why. I thought we made it clear in our malibongwe dialect. Perhaps it wasn't. The time for good morning, how are you, is when you introduce yourself in chambers. That's one of the reasons. That's where the humanity comes into play. We don't, it's not court jargon to say good morning, justices, how are you, justices. So that doesn't happen in the courtroom. It happens when you introduce yourself. So in the courtroom, it's as it pleases the court, as it pleases, so it's as it pleases the court, as your ladyship pleases, as his lordship pleases. But we don't really say good morning or how are you. It doesn't happen. That's why we have the introductions. Because the introductions, I don't believe there's any reason to ever dispense with an introduction. So if you've never met a judge, you always introduce yourself to the presiding officer, and that's court etiquette. So then what happens? You can engage into and we go into the matter because now it's business. We've already met. We don't need hello and goodbye. So I don't know why that wasn't happening. I thought it was clear So you generally, and especially when it comes to monetary amounts, it's recurring mistakes. So if you have duplication, there's either typographical error when it's typed wrong, then you can quickly rectify because it's clear. The 1 million rand is written out in full, and this becomes important later. The other thing that I noticed was abbreviations. So sometimes you may either want an index with the abbreviation. So you know, I needed to look through the document what this meant. So either it's at the beginning or there's an appendage at the end that says abbreviations, and quickly, if I need to open one page at the bottom. But that's just semantic and not really the core. The thrust is respect. And because you have brought all this work, I will share with you now what was shared with me by a leading elder in the profession. And I use it, you know, when I prepare my matters. I take cognizance of it. So how do you win a case? You win a case simply with two things. Premise on respect. You must 1 to the judge to 5. So you need to build the 1 to the judge. Judge is 1 to 1. And then the second way, after you've built the 1 to, you show them how. And remember, when you deal with the judiciary, they all have thoughts on the law. So sometimes, when you're dealing with a very clever judge, and not to say our judges are clever, but judiciary is clever. So when you're dealing with the judiciary, sometimes just to roll the 1 is enough, because they will know how to find the way. But most of the times, we are already in the process of showing them how to find the way. But case how you show it, and don't forget you're dealing with human beings. So that's actually what I do. And then you build a case. It's not overt, it's the undercurrent. So you're dealing with a persuasion, and you're persuading a judge. So they want to find for you. And how are you going to make them want to find for you? Find a solution for the crime and so on. Find a solution for us. What is going to speak to deal with the spurgeon crime? Then build on it. And then legally, how do you find that? And then sometimes if the want is there, the branch together will find that way for you. So we all want to find a solution to this spurgeon crime. We all want a crime-free society. So if this issue is ever before the court, believe you me, the justices are going to grapple to come with the best solution to protect all of us. So I look forward to your continued advocacy, and I want to commend you. And we will adjourn briefly to deliberate on the awards. And I think a 15-minute adjournment is sufficient. And we will then engage. So court is officially